Hi, folks. I am Jill Martin Diaz. I use they, them, or ella pronouns, and I am an immigration attorney and the executive director of Vermont Asylum Assistance Project. We are a statewide legal services organization that provides direct services, coordinates pro bono support, promotes community education, and engages in systems advocacy to advance immigrants' rights. This is the first of what I hope will become regular VAAP Top 5 immigration practice alerts. We are truly overwhelmed by the volume of communications, the volume of requests for our legal expertise. We so appreciate the community's engagement with us, and we want to be there for as many people as we can with our very limited resources. And so, um, we're going to be using video recordings and social media and our website, www.vaapvt.org, and also our social media at VT Asylum to try and spread the word. And we'll be recording these materials in English and then looking to community partners to help us get the message out in the other languages that are commonly spoken in our communities. The theme today for today's updates is when the tools no longer work, rethinking legal strategies in a failing system. VAP is traditionally staffed by direct service providers. We help people to apply for benefits from the immigration benefits granting agencies and to seek relief before immigration administrative courts like the Immigration Court. And what we're seeing is a number of changes in the Trump administration that is causing us to rethink our strategy and to shift the way we think about benefits work. We're now going to be helping individuals apply for benefits, understanding that those benefits are not likely to be granted or granted quickly, that they're likely to be denied, and that VAP needs to be focusing resources on helping people to submit appeals and to file lawsuits in federal courts when the agencies are administering the immigration systems incorrectly in violation of the law. So, the top 5 updates for this week. One, people need to understand that harmful federal immigration laws that were created by Congress and already existed before this moment are now being dusted off and implemented to the fullest extent possible. In some cases, they might be implemented beyond the scope of the power, and that's when national partners are filing lawsuits. An example of a legal change that's happened recently is the dusting off of the USCIS registration requirement. VAP will be recording a education program, a virtual webinar with other community partners soon to go deep into the registration requirement. But in summary, what it is a requirement that anyone who crossed the border into the U.S. irregularly, whether that was to seek asylum, whether that was to enter undetected to engage in employment, now needs to affirmatively file a form to register their presence and their biographic data with USCIS and carry proof of that registration on their person. And if they are come into contact with immigration authorities and have not done those two things, then they could face civil or criminal liabilities, including up to 6 months incarceration. And any criminal liability increases an immigrant's chance of deportation. The issue with this program, there are many, is that the form asks for lots of information, and a person is not likely to want to share a lot of information about themselves, the places where they're living with their families, family information, etc. And if a person is found to have committed fraud, to willfully submitted wrong information or withheld wrong information in applying for an immigration benefit or submitting a form, that can create even worse consequences for their immigration prospects down the line. So this is going to be a really technical and complicated program that gets rolled out. The deadline is April 11th, and VAP and community partners will be releasing a special webinar to help inform the public about this USCIS registration program and how people can do a cost-benefit analysis to weigh the pros and cons, see if they decide they want to register or not. Because Vermont lacks direct legal services risk capacity, we're all but sure that there won't be legal assistance available to counsel individuals on whether or not they register. So that's why we're thinking about other kind of internet and group-based approaches to helping people learn about the program. So top 5, point number 1, harmful laws that are already on the books are now being implemented. Top 5, point number 2, there are a slew of policy changes underway, helpful policies that were on the books from the last administration are being replaced with more harmful ones. Harmful policies from the last administrations are being fortified by the new one. And some of this is within the president's power. Some of it exceeds the president's power. And again, that's why national law firms are filing suit to try and hold the government accountable where it's changing policies in violation of the law. An example of this would be Friday's news just this week. So today's March 26th, whatever day Friday was. The federal administration officially canceled the unaccompanied children program funded through the Office of Refugee Resettlement. And that's the funding that was responsible for VAAP's 2 IJC attorney fellows, Immigrant Justice Corps attorney fellows. So VAAP has lost half of its funding and overnight. And there are lawsuits being filed by national partners. VAAP is being represented by a team of national litigators as an organizational plaintiff, and we're contributing some facts and materials toward the representation to try and challenge this policy decision, alleging that it's illegal under federal law and constitutional law and citing all the reasons. So we'll keep folks apprised of how that litigation proceeds. As of right now, our IJC fellows do continue to be employed by VAAP, and we are working around the clock to replace their funding so that there's no interruption to their employment with us, as they both have full caseloads of direct representation cases. So top 5, point number 3, we're hearing and experiencing ourselves reports nationwide of the executive agencies that are responsible for the immigration system violating their laws and policies. USCIS is returning applications. They're rejecting applications that we're filing, citing pretextual deficiencies in the applications. Notices are getting lost. Biometrics appointments, like fingerprint appointments, the notices are getting lost, and it's really hard to get them rescheduled. So we're seeing some concerns happening over there. We have not yet heard of illegal referrals from USCIS to ICE for removal proceedings in the event that CIS is denying applications. So we haven't heard that. But today, the Trump administration released a policy notice saying that they're not going to be adjudicating green card applications for humanitarian applicants like asylees and refugees. Of course, this is devastating to our many community members who are waiting for family reunification. So what we're seeing is the benefit system is slowing down either by policy or functionally. We're seeing them not adjudicate anymore, and we're seeing them reject filings when they can. And people can expect that when they apply for stuff that it's not going to get adjudicated, right? It might just be sitting in the system for a long time, maybe for the pendency of the administration. We're also seeing ICE and CBP here in our border zone. Vermont is within the 100-mile border zone, and we're seeing ICE and CBP violate constitutional due process laws, asylum-seeking rights, due process protections in the immigration laws with respect to expedited removal and immigration court removal proceedings. And we are trying to pivot our litigation strategy to help hold the government accountable to the rights and obligations it owes the people it interacts with. And we're also seeing the immigration courts, which are administrative courts. They are not courts that exist in the judiciary, in the judicial branch. They exist under the purview of the president, which advocates have been pushing back on for decades now. But the immigration courts are also rejecting filings for pretextual reasons. Our nearest immigration courts are in Massachusetts. It's really difficult for us to file anything with them because we have to file by mail, and we're not there to push back on the clerk when they want to reject filings for pretextual reasons. So we're getting a lot of rejections, a lot of inconsistencies in the way courts are managing their dockets. The executive branch is trying to take away individual judges' ability to manage their dockets. And so, similar to USCIS, our immigration court practices are slowing down quite a bit. And every case is just taking a lot more resources in order for us to make sure that each individual client is getting the zealous representation to which they're entitled when they retain us as their counsel. So yes, there are law and policy violations happening across all three branches of government. That doesn't mean that we don't have remedy. It just means that our work is taking more time, more energy, and that each individual case is going to require a lot more attention to actually get stuff filed, make sure that stuff is processing through the system the way it should be. Top five, item number 4 is that yes, people can and should, if they want to, still apply for benefits and comply with their proceedings and engage with the system. They should just expect that there will be slow or no decisions on their USCIS benefits. And they should expect the need to appeal denied applications by USCIS if that's where they're applying, or denials for relief by the immigration judge in immigration courts that are presiding over people's removal proceedings. So we need to start to normalize the posture of losing. This is already the case in other federal benefits systems like Social Security. Admittedly, the stakes are very different for individuals in removal proceedings who are facing banishment from the United States for the rest of their lives. But this is not unprecedented in federal administration systems to have the initial applications or even the first line of appeal to be denied as a matter of routine, and to have lawyers intervene higher up in the proceeding, at the appellate level to try and create some remedy for the individuals who are seeking protections. So we at VAAP are skilling ourselves up. We're going to trainings and we're diversifying our strategies so that we can meet this moment. It's still important for people to apply for benefits if they want to, and they have the claim and they have the ability. Just understand that it's going to be it was already a long road to resolution, and it's going to be an even longer road now. And then the top 5.5 that I want to share for this week is I just want to honor the decision that some people might make once they've looked deeply into the costs and benefits of the different options available to them. There may very well be community members who decide that what is best for them is to not engage with immigration agencies at this time. They might decide that they don't want to apply for relief and bring themselves to the attention of government. They might decide that they don't want to comply with supervision by ICE or registration with USCIS requirements. It's important that we make sure everyone really understands big picture, the risks and consequences of the different options available to them. We're going to be circulating information to help with that decision making. And we just want to honor some people might make that choice, and that's their choice to make. We as attorneys are not allowed to counsel someone to not comply with the law. However, we can speak generally about the risks and consequences of different choices people might make, and we can speak generally to the trends of behavior that we see in our practice. For example, unauthorized work is prohibited in civil immigration law, and it is also contemplated by the tax system. An unauthorized worker is expected to get an individual tax identification number, an ITIN, and to file taxes every year, even without authorization. In fact, it's a source of income that the US government really relies on. And I can't tell people, yes, you can work without authorization, but I can explain that I have, in my 10 years of practice, never had a client who is not working. And almost none of my clients are work authorized when I meet them because they all have rent to pay. So that was the top 5 for this week. What I suggest is that you follow us on socials, you subscribe to our newsletter so that you can stay abreast of how we're adapting our services, how we're reaching out to our community partners and fellow service providers, not just in Vermont, but regionally and nationwide, to make sure that we're changing our practice in step with national best practice so that we're giving Vermonters access to the best available information at any given time and the best available service at any given time. Thank you so much for all you do. Subscribe to our newsletter online, and please take care of each other. Thank you.